Good afternoon, everyone. I am Jeremy Glover, a partner at Fenwick Elliott, and thank you for attending what is now our fifth Fenwick Elliott webinar, which today looks at claims. A brief reminder that you're all on mute, but if you do have any questions, please use the question box, which should be on your right. All questions will be anonymous, and as chair, I can happily pass the difficult ones to our guests, so please don't be shy. And I mean that because we've found that people tend to ask questions when the Q&A session actually starts, which makes it less likely we will be able to turn to your question. So why claims? Well, it's quite simple, really. There's been a lot of talk about what is force majeure. There's been a lot of talk about serving notices. But if you served a notice, you can't leave it there. At some point, you'll either have to make a claim or you'll be the person who's reviewing a claim that's been submitted. So we thought we'd take a look at some of the key issues that might arise in putting a claim together. And I'm lucky enough to be joined by two experts in their field. Lynne McCafferty deservedly made a QC in 2018, greatly experienced in all aspects of construction law at home and abroad, including the Middle East. She's also been involved in the Grenfell Tower public inquiry. Lynne has been described in the legal directories as great on detail, which is a key skill for dealing with claims. But my favourite quote is that she has a quite wonderful technique of slowly, calmly, and precisely taking witnesses apart in cross-examination. George Taft, a managing director at Secretariat, is widely experienced across the board, dealing with contract administration, commercial management, claim preparation, etc. He's highlighted as a global leader in his field by all the directories. George has worked on both sides of the fence for employers and contractors, and on a number of major projects, including the Panama Canal expansion and the Chernobyl New Safe Confinement project. So what are we going to talk about today? We're going to look at the essential elements of a claim. We're going to look at causation, perhaps inevitably records, productivity, and also the duty to mitigate. So what are the four essential elements of a claim? Cause, effect, entitlement, and substantiation. Now, I think our point is, we know that you all know this, but time and time again, we see claims put together which don't deal with these four key elements. They simply tell the story, and it might be a really interesting story, but that's not good enough if you want to make a successful claim. You've got to think about cause. What's the event that's given rise to the claim? How do you link the cause with the effect? What's the entitlement? What are the breaches of contract that you are relying upon? And how are you going to prove that the statements made and the points you're actually relying on actually happened? How do we know that they're actually true? And it's all about linking cause with effect. And towards the end of last year, there was an Australian case where the judge dealt with this at some detail. He recognised that sometimes one of the flaws in people's claims that they simply assume the situation. It's not enough to be saying that there was COVID-19, therefore I'm entitled to an extension of time. He also noted that the court was concerned, the Australian court, concerned with common law notions. The only appropriate method was to determine the matter by paying close attention to the fact and assessing whether the party had proved on the probabilities that the delay in the underboring solution had delayed the project as a whole. Now, delete the words "in the underboring solution" and insert the delay caused by the force majeure or the delay caused by the COVID-19 effect, and that's what you need to be thinking about when you're putting together a claim. But this is something that Lynne can talk about in more detail.
Thank you very much, Jeremy, and good afternoon, everybody. I'm delighted to be able to join you today. The case that you've raised, Jeremy, is an excellent example of something that I think we've probably all been talking about with clients for so many years. Delay experts and quantum experts, of course, can work wonders, and they are absolutely essential to claims of this nature. But they can't create a persuasive and cogent case out of thin air. They need evidence, and the best kind of evidence is contemporaneous evidence from the ground, people who were involved day to day in the project. Whilst the experts can marshal this data and synthesise it into a compelling narrative, ultimately their reports are only as good as the evidence that the claimant provides them with. The case you mentioned, Jeremy, of White Constructions and PBS Holdings, as I said, is an excellent example of this. Although it's a decision of the Australian Supreme Court in New South Wales, I think the principles apply equally to this jurisdiction. And my experience is that the insight that the judge gave in that case to the judicial consideration of evidence is very much consistent with the sorts of approaches that I would expect to see in the English courts from judges, and also in international arbitrations and adjudications. Now, that case concerned alleged delay to a development that was said to have been caused by the failure of the sewage designer to provide a design that would satisfy the local water authority. The judge, in the end, held that the claimant had failed to establish that there had been a breach of duty, and failed to establish that any of the delay was actually down to the sewage designer, and he dismissed the claim. But very helpfully, he nevertheless spent a considerable amount of time going through the evidence on delay and the quantum evidence as well, to give some pointers as to how he would have decided the case if he had held that the delay had been caused by the designer. Now, as is often the case, the delay experts disagreed about what method to use for the delay analysis. They disagreed about what the others' delay analysis showed. And so the judge appointed his own expert to... Sorry, I think I just went muted there. The judge appointed his own expert to look at the delay analysis on his behalf. And he accepted that expert's analysis. And what he said there was that that neither delay method was appropriate in that case, and that what was needed was close consideration and examination of the actual evidence of what was happening on the ground. This will reveal if the delay in approving the sewage design actually caused a delay in the project. And he said the court should apply common law, common sense approach to causation. Now, he went through in some detail in the circumstances of that case what was required. And he said really that the complexity that has been introduced by the expert delay analysis was something of a distraction. He focused very much on the primary source of evidence in that case, which was a site diary. And he criticised the witness evidence of a site foreman, which he said there was couched in generalities. And he said it didn't give enough consideration to this site diary. The site diary was described by the judge as being very well kept, and it was helpfully organised into different sections, such as contract works completed today, client instructions received today, delays today, and so on. Now, the judge complained that despite his exhortations that he should be directed to this raw data, that the claimant, in fact, took the judge to very few of the contents of this site diary. He described this as an important contemporaneous record. And when the judge examined it very closely, he discovered that there was a paucity of references concerning the delay to the sewage design. And really, that was the overriding factor in the judge's rejection of the claim. So, as I said, my experience is this is exactly the kind of approach that a judge here would take, or an arbitrator in international arbitration. And there's a helpful quotation from Keating on construction contracts, one of the leading textbooks here, which says the very same thing. It says it's important to emphasise delay analysis and the programming evidence associated with it is just one tool to assist the fact-finding tribunal. It should be based on contemporaneous evidence of what actually happened on site, and delay analyses are never a substitute for relevant and convincing factual evidence. So just to tie up those loose ends there, what lessons can we learn from this? What lessons can a claimant contractor learn from this case? I think the key thing is you need to, throughout the project, establish and then maintain a detailed site diary or record of some sort. And the sorts of things that needs to record on a daily basis is who's on site, what personnel have you got there, what they're actually doing day to day, which part of the site they're working on, what's holding them up, what instructions are coming in. And what's really helpful is if you can back all that up with further records, timesheets, worksheets, site diaries that are recorded and noted by site foremen of meetings they've held and problems that have come up on the project. And you need to retain those records. I've lost count of the number of cases where I'm told once the dispute has arisen that there were wonderful records, lots of timesheets, but they were discarded or they were lost in a fire. And you need to keep hold of these records because they are incredibly useful, and the delay experts and quantum experts can't work their magic without them. So really my big piece of advice for you all is that contemporaneous evidence really is the key to success in these sorts of claims. And that's perhaps a convenient moment to pass the baton over to George to talk more about that from his perspective.
Thank you, Lynn. I'm delighted to be a part of this webinar, and what my comments here will be from on the basis of my background as a quantity surveyor and a quantum analyst in dealing with the claims and the sort of subjects that we've been discussing. So what I want to start with is on the subject of causation. I just want to think in practice about some of the practical steps, but also to use this example of COVID-19 and the sorts of causes and impacts that that one will be thinking of. So here on this first slide that I have, you can see I've got 6 points there, just outlining the sorts of issues, the sorts of causes that many construction projects will be encountering. I won't read them out there, but you can see it's a range of effects, some of which are sort of widespread effects that could affect progress on the site, but other items are specific discrete items. There may be additional direct costs, such as point 6. So just going on, thinking in the context of those causes, the first practical step that I would always consider as necessary is for a construction project and the contractor's team to think about, we need a strategy and a plan. So the first thing to do is to establish the issues, the specific events for which you're claiming, the routes of recovery through the contract, because obviously there may be provisions that guide us to, first of all, what can be claimed and how they should be evaluated. And to consider the specific events that are being claimed, and then the effects that flow from each of those events. And importantly, this should be maintained, particularly for something like COVID-19, where the effects and the impacts are changing depending on the restraints. It should be maintained as a live document that can be developed as time goes on. I just wanted to raise just a few other considerations, that some of the restrictions, and this plays back to some of the comments that Lynn was making, some of the restrictions, of course, may look like there will be an automatic cause leading to an effect, but they may not always actually lead to delay and disruption. So I've just given a few examples here, and we'll come back to this in some of the subsequent slides, but things, for example, like the need in terms of hygiene for frequent hand washing or social distancing, one needs to consider whether there is in fact an effect. So theoretically, one might think, oh, there must be a disruptive effect, but in some situations, it may not lead to an additional cost, and that's a point that I'll come back to later on. Of course, when you're thinking about the effects, a particular event causing an impact, there are primary impacts, but there may then be secondary effects, things that are a knock-on effect that will cause other things. But the important point at the bottom there is, from my perspective, looking at the quantum, the challenge is that there needs to be traceability established between what the cause is and then the effect, and ultimately the cost arising from it. Because if you can't point to that and demonstrate that there is traceability, then the claim will be shown to be flawed.
Thank you, George. And of course, when it comes to claims, you've got to talk about records, and to some degree, that's all it is. It's about records, records, and records. And once again, I know that you've heard all this before, but there's a reason for that. It's fundamental. Just this week, Arcadis produced the number one cause of construction disputes in 2020 is poorly drafted or incomplete and unsubstantiated claims. And they're incomplete or they're unsubstantiated because they don't have proper records. Going back to basics, the SCL delay and disruption protocol, that talks about in core principle number one, it talks about program and records. It says that contracting parties should reach a clear agreement on the types of records to be kept, and they should allocate the necessary resources to meet that agreement. And that's something that's a gold standard. It's not something that everyone always does. It's something that people aspire to. But Secretariat and George, just a few weeks ago, took that point in mind, and they brought attention to it in actual terms of what people parties need to do in respect of COVID-19, when they said that contractors and subcontractors will need to develop and shape bespoke record-keeping systems. You've got to actually react to events, and they recognise that the traditional project controls are unlikely to capture the relevant information needed. And George, if you want to expand upon this a little bit, thank you.
Yes, the points that Jeremy just referred to there in our LinkedIn article back in early April. Let's think about that in the context again of COVID-19. And again, on this slide, just to get it practical, here are some of the issues that would be faced on many construction sites as a result of COVID-19. And so for each of these types of issue, one needs to consider, well, in practice, what are the sort of records that would be needed? What would be suitable and appropriate? And you can see at the bottom of that slide, one needs the right records recording the right events. But there is a challenge here, of course. There is this issue of proportionality. And if you think back to the White versus PBS case that we looked at earlier on, it referred to proving the case on the probabilities. And we need to consider, what does that mean, particularly when we're trying to assess and evaluate a claim? What needs to be shown? There is an issue of proportionality here. And so on this slide, I'm just noting here that there must be sufficient relevant records to show that the claimed effect and the cost was likely to have arisen from the claimed cause. So, for example, if you think about the example of hand washing and sanitizing breaks, it would be practically absurd to think now that all personnel need to have a record for every time they stop to do that. Of course, there may be certain causes that are recurring of a significant nature where one could establish a cost coding or referencing system to ensure that site personnel are recording certain types of time expended as a result of a particular issue. But if we just think in terms of repetitive tasks, and as I say, thinking of things like the hand washing and having to take more breaks, it might be useful to think in terms of sampling, because in my experience, sampling is an approach that is often considered proportionate and appropriate, and tribunals and courts will typically be persuaded by such approach, as long as it is undertaken properly. And so with this slide, I'm just outlining some of the issues that should be considered when considering sampling. So this is where you would, if there is a pervasive issue that's affecting a range of personnel, that you could conduct a sampling process and say, okay, for these types of trade people, operatives, we're going to analyze the effect of these break times on their production rate. You conduct a sample test and you have the evidence to support it. But the important thing is that that sample must be shown to be representative, you know, that you've not skewed it to select a sample that is a heavily affected element that then would be wrong to extrapolate. And obviously you must be able to show that it does recur, so that this sample can be used to extrapolate across maybe a particular trade or a particular set of activities. And of course, as I note at the bottom there, COVID-19, the impacts are evolving, they change, so any such assessments will need updating.
No, I think, George, that's absolutely right. It's an evolving situation, and one of the issues that we're finding of particular importance at the moment is productivity or lack of productivity. It's a key issue. Contractors are now returning to site, and the question is, are they able to achieve the productivity rates they had anticipated? When they came back and thinking, oh, we're only going to be work at 25%, it turns out they might be able to work at higher rates. And just as a reminder there, what we're talking about when we're talking about loss of productivity, we're also talking about disruption. And there's just the definition there, again, going back to basics and looking at the SCL delay and disruption protocol. But George, are there any sort of things that you've noticed in particular relating to productivity and lack of productivity issues?
Yes. So I think when we're talking about productivity, obviously the first point is to understand what it is we mean by this. It is important that when we refer to productivity rates, this is where for a particular activity, a construction activity, there is an output, an hourly output or a daily output of work for a given gang size. So when you're testing this, obviously the important thing is that productivity, it must depend on the facts. Again, it comes back to records, what you can show the impact is. And the second important point is the importance of establishing the baseline that you're measuring from. If you say, right, we're going to undertake this test on actual productivity rate and say that this is how it's been affected by, for example, social distancing, but what do you compare that to show the reduction? So one has to look back at the contract, what was sensible to have allowed. And again, as I'm sure many of you are familiar with disruption claims, typically the terminology that's widely used is measured mile. You need to look back before the impact emerged and say this is what we can show was the production rate for these activities before this impact came into play. And I've just got a couple of quick examples. This issue of baseline. Downtime, for example, I was discussing with colleagues in other parts of the world. For example, in hot and tropical countries, they will have a certain frequency of breaks. So that means that in the case of COVID-19, if you're having to undertake sanitizing, hand washing breaks, it may be that the effect won't be significant, if at all, because the baseline you would work from is that they were having regular breaks anyway. And I've just very briefly there referred also to what I experienced when I did some work on Chernobyl, on the new safe confinement project, where again, there were restraints that were understood at the outset and priced for by the contractor. Because of the effect of radiation, they were only permitted to work, operatives within a certain distance of the older reactor had to take a certain frequency of breaks and not be working for prolonged periods. So again, there'll be a baseline that would have been allowed. So you should only consider the impact, the layering of effect of the new impact against the level of production that would have been encountered in the baseline. So just one more slide here, and I recognize there's some big subjects here and we could go on at length. These are just some some further points. I've already mentioned social distancing and how there are certain activities which could, of course, be affected by that, where there are operations which need more than one person in close proximity. But other examples include a reduced rate of supply of materials. So suppliers might be on stop or working at a reduced rate of production, or indeed subcontractors. So again, your reduction in productivity, you would need to look at the records of material deliveries to show what was reduced, the evidence of that, and then the connection of that reduced rate of supply and how that affected the operations that required those materials. And then the final point there, in terms of the impact of the programme, one might need to consider the impact of this reduced production rate, how that would then affect the speed, the duration of the affected construction activities. And so one could then project forward and say, well, this is the effect, this is how slowly these activities are now being conducted. And then you can then look at what would be the overall delay effect. But there is a question there: how far into the future can you proceed with that analysis, and what level of production rate, the reduction, what would be appropriate to project? And so those are questions that are particularly pertinent where there is a prospective approach being taken. And of course, there are some contracts, such as the NEC form of contract, where that approach is what is set out in the contract. And so one has to consider, on a prospective approach, what is reasonable, and the evidence you would require is to look at what the actual effect is now as your source evidence when you project forward. Oops, sorry. And then the final point is, when it comes to all of this analysis, one must avoid a global approach that groups together too many operations, or just an operation across the site, and then just compares an overall production reduction with the tender or other norms. If you do too much of a global approach and grouping too much together, then such an approach that could be shown to be flawed if there are other issues affecting production. Instead, one needs to consider the specific effect. So in the case of COVID-19, what is the effect of those impacts, and what are the activities affected, and by how much? So if you make it specific and isolate the causes, then you won't fall foul of that particular issue.
No, that's brilliant, George. And once again, I mean, it's clear it's not just enough to say it's COVID-19. You've got to be looking to demonstrate that it's causing direct loss or direct delay. And our final topic today is another topic that's quite often, forgotten about, the duty to mitigate. It's there in all the contracts, whether it's obviously like the FIDIC form of contract, which actually tells you have to minimise any delay. It's not so obvious in the NEC form of contract, but it's there. There's obligations on the contractor to minimise and reduce delay to actually mitigate the effect of the events. And if the contractor doesn't do that, then it's going to have an adverse effect on their claims. But I think this is something on which Lynne can elaborate further.
Yes, that's right. You're absolutely right there to draw attention to these specific express duties, in particular standard form contracts to mitigate. Often I've found that there are further specific duties to mitigate which are set out in amendments, the bespoke amendments to those sorts of contracts. So I think it's really important to check your contract, check the schedule of amendments to make sure that you're not missing something, because the key thing is that you've got to show, even if the employer is responsible for the delay and you feel very sure about that, you've still got to be able to show that you are complying with your duty to mitigate and that you are making progress during the course of the continuing works. There's also an overarching duty to mitigate loss, which applies generally in the English law and in other jurisdictions as well. So that's on a more general level. I think what we're interested here is what can you practically do to comply with the specific express duties in your contract. So in practical terms, in order to show that you're still proceeding with the works diligently, the sorts of things that you'll need to do are produce an updated programme, for example, to show how you plan to try to recover or mitigate the delays that are being caused by the employer. You have to keep reporting on progress, obviously, keep maintaining that site diary or site record that we talked about at the start of the seminar in relation to the White versus PBS case. One strategy that I've seen used quite effectively in the past is to consider whether there's any scope for acceleration of the works, and if so, to put together a proposed acceleration programme, the cost of that, and set that out to the employer to see whether they might go for that. That's a possible strategy. But one thing that I would say is really key is you have to keep communicating with the employer about what you're doing to comply with your duty to mitigate. So not only in progress reports and minutes of meetings and so on, but also set it out in project correspondence. Send letters, and you'll need to get in-house counsel to help. You may need to get your solicitors involved to help with this, but set out in these letters that you understand you have a duty to mitigate and what you're actually doing practically on the ground to comply with that rule. And that will help enormously in being able to show that you are, to show a judge or an arbitrator further down the line that you have complied with that duty.
I mean, communication is key under any circumstances on any construction project, and that's a fundamental point that people should always bear in mind. And George, I mean, do you have any other comments on the duty to mitigate point?
Yes, just on this final point, my first thought and my first point was obviously, yes, consider the contract and take legal advice in consideration of the country and the jurisdiction. Because obviously that could have an effect, as Lynne has just been describing. As a general point, mitigation steps should of course be reasonable in the circumstances. And I think the key point, my third point, is that it is crucial to advise the other party to consider the options that have been considered and which option was chosen to be implemented and why. And of course, the important thing is that mitigation steps, what you're looking for is the best means of reducing the cost or the delay effect at the minimal cost. And you can see there a key point I've said at the bottom there, the golden rule is that of course the total cost of the mitigation measure should result in an overall net saving, otherwise it's not mitigation. And when I say overall net saving, that is net saving against what was going to happen had the mitigation effect not been undertaken. And you'll see there that those points I just referred to resequencing, that is a common means of a mitigation step which may not require much additional cost, but of course there may be preliminaries, thickening, increased level of supervision that may result from such a resequencing approach. So I think those are the only practical comments I was going to make on that heading.
No, that's brilliant, George. Thank you very much, and thank you, Lynne, too, for your comments. And thank you, those of you who are listening, for the questions that have been coming in. Happily, you haven't been shy, and we've got a number of questions that we can discuss. One point, and perhaps if I direct this to you, Lynne, we've been talking about what contractors and what parties should do if projects fall into delay. What about those who haven't been doing anything or haven't been keeping a proper record? What should they be doing? Are they doomed?
Absolutely not. No, it's never too late to start putting together the documentation. And one thing that could be effective will obviously get started straight away with maintaining a site record, using the tips that we've talked about earlier, setting out what's happening where, who's doing the work and so on. But I think a really useful thing you can do at this stage during the project is get somebody dedicated to going through what records you do have, what information you have got available, to put together something that will help explain to a delay expert, to a quantum expert, and ultimately to a judge or an arbitrator what's been going on site. Too often what I find is that by the time the lawyers get involved further down the line, the dispute has arisen, months if not years have passed, the key people on site have left, they've gone to another project or another job, and then you're faced with the difficulty of the experts having to sit down with somebody who didn't necessarily know the job very well and trying to retrospectively piece it together. What you want is somebody who was involved in the actual project on the ground, who has got the facts to uppermost in their mind, who can sit down and start to piece together what's gone on and where things have gone wrong, so that even if it's not an exact contemporaneous record, you've still got something better than nothing to give to the experts and the lawyers.
Okay, no, that's perfect. That's excellent. George, a slightly different question for you. Well, I suppose we all have. We've mainly been talking about the impact on contractors, the impact on construction, the construction projects, the construction process. What about consultants? What about the impact on design and designers? How do they fit into all this?
Yes, that's an excellent question, and it is actually, thinking about it, I can think of numerous instances coming to mind that I've come across where there are design impacts and affecting the designers and indeed other consultants, and sometimes they can be more problematic because the issue, it goes back again to records and evidence, that sometimes things are perhaps not monitored as much and the records aren't there to enable it to clearly be shown what the effect is and what the valuation should be. I have actually seen, I'm aware of some instances of social distancing resulting in construction operations which would have been adversely affected, and of the design team looking ahead at what can be done to avert that loss of efficiency by, for example, undertaking design detailing and impacting the fabrication. So, for example, you could look at BIM, that's the building information modeling, and you could look at the how you can undertake more off-site fabrication to result in a more efficient construction process. So ironically, it could almost lead to savings on the construction site, but there will be an impact, obviously, both in terms of the design process and the costs involved in that, and also there could be a delay, obviously, because of the implementation of those measures. It could mean that the construction itself is pushed and the start date is delayed. But the key thing is, again, for the design team that is dealing with that and others who are involved in that process, is again to be maintaining records of allocation of timesheets on those exercises that were precipitated by the event.
Okay, no, that's very helpful. Thank you, George. We've got time for one more question, and it's a late question that's just come in. I think perhaps that because of Lynne's reference to the judge and the arbitrator, of course, a lot of disputes in the UK and across common law are determined by adjudicators. How do adjudicators approach these issues? Will they take the same approach as the judge in the White and PBS case?
Yes, I think they do actually. I know that there's a perception that you can get away with more in adjudication because, of course, it's a rough and ready form of dispute resolution, and there's just less time for the adjudicator to go into all the details in the way that a judge or an arbitrator would at a lengthy hearing. But what I would say is, my experience actually is that adjudicators, particularly the good adjudicators, are really good at cutting through the detail of the delay expert and the quantum expert's reports and identifying what actually underlies those arguments, and that they can tell, that they can see quite clearly where there are contemporaneous records that are backing up what's being said. And actually what I found is really that you still need that same level of proof, that same amount of contemporaneous records to persuade an adjudicator, whether it's a construction professional adjudicator or a lawyer adjudicator, that there is a real compelling basis and factual basis to support what your experts are saying underlying it. So really, I don't think there's a great deal of difference in the way that they approach it and the thinking that they apply to it.
Okay, George, do you agree with that?
Yes, I would obviously be very hesitant about disagreeing with Lynne, and I would say that in practice, the issue is, I suppose, is if it's an adjudicator, if you're really trying to do the job properly, then of course, yes, there shouldn't be a difference. But in practice, sometimes you do see a difference, and people sometimes refer to it as rough justice, which of course it shouldn't really be. But obviously, the constraints and the quality of the adjudicator can sometimes have an impact. So that would be my only comment from my own experience.
No. I agree with all of that. So I think time has now come to an end. So it just leaves me to thank George and to thank Lynne very much for your contributions. They're much appreciated and very clear, very practical. So thank you for that. Thank you all for listening and contributing with your questions. Just like to remind you that next week, moving to slightly further afield, and I will be chairing the webinar with my colleagues Ahmed Ibrahim, who's managing partner of our Dubai office, and Patrick Stone, who also works out of Dubai. And they'll be discussing the differences in the payment provisions and practices between the Middle East civil codes and the English common law. So I hope that you'll be able to join us all next week. Thank you very much.
Thank you.